Great. So now we are into chapter 3 today, which is consent and form, section 234 to 240 and section 247 of the BNS, which is part of the chapter 18 of the BNSS, which is the charge. The first set of sections 234 to 240, what we will read today in chapter 3 are from chapter 18, part A, which is form of charge. And the 247 is in syllabus, chapter 18, the charge, which is part B, joinder of charges. So section 234 is something which is the section is about the contents of the charge. And it does have some illustrations also given, which we'll slowly examine once we go further. So basically what it says is that every charge under this Sanhita shall state the offense with which the accused is charged. So whenever the matter reaches to the charge state, what we do is we present the accused with the charges, and the Sanhita says that every charge under the Sanhita shall state the offense in which the accused is. So when the accused is charged, it has to be clearly saying that what kind of offenses which the accused is charged with. Subsection 2 says if the law which creates the offense gives it any specific name, the offense may be described in the charge by that name only. So it has to be charged by that name only. The names cannot be invented just because of a convenience. It has to be, it's not a literature school, the courts. The courts follow the process and the procedures, and the law is very, very specific about the definitions of the word. The same word could be defined sometimes differently into different acts and the sections, acts and different laws, and that is why it has to be respected to the teeth. Now, if the law which creates the offense does not give it any specific name, then what will you do? Then so much of the definition of the offense must be stated as to be given the accused notice of the matter with which he is charged. So something meaningful has to be given. Subsection 4 says, the law and section of the law against which the offense is said to have been committed shall be mentioned in the charge. So it has to be clearly mentioned in the charge, the law in the section. So IPC section so and so, BNS section so and so, POXO section so and so, Cosmetic Act so and so, so and so forth. Subsection 6 says the charge shall be written in language of the court. So whatever is the language of the court, it has to be written in that. And subsection 7 says if the accused having been previously convicted of any offense is liable by reason of such previous conviction to enhance the punishment to be punishment of a different kind for a subsequent offense, and it is intended to prove such previous conviction for the purpose of affecting the punishment which the court may think fit to award for the subsequent offenses, the fact, date, and place of the previous conviction shall be stated in the charge, and if such statement has been omitted, the court may add it at any time before sentence is passed. So this is something where if the court has intention to bring in the previously conviction or any offense for which he is liable by the reason of the previous conviction, for the punishment, some other type of punishment is to be added, and for a subsequent offense for which the person is being charged and right now for the previous conviction. So in that case, the whatever is affecting for that fact, that date, and the place of the previous conviction, etc., has to be added in the charge, and such statement has to be, if such statement has to be omitted, then the court may add it any time before the sentence is passed. So let's first examine the first 7 subsections. So the very first section is talking about the statement of the offense. So every charge under this Sanhita shall state the offense with which the accused is charged. So the core of the charge must be clearly stating the offense with which the person is accused of. And this is basically a fundamentally for the accused to basically to understand basically the nature of the allegations against them. So the charge should be clearly state what kind of offense against which the person is been accused. Then subsection 2 says that the specific name of the offense has to be given. So whatever the offense has a specific designation in the law or a specific definition in the law, the charge can simply refer to that name. And this allows for the precision and ensures that the legal terminology is aligned with the established definition of that particular law. For example, if I have to come back and charge somebody of a crime which is against a minor, I will not use the word junior or not adult. I'll go ahead and use the word minor there, which is in alignment with the definitions in that particular law. So that is why, that is how it has to be done, so that it will be then interpreted accordingly. Wherever the in BNSS or BNS, now wherever you will talk about the sections around the minor, automatically it will align to minor. Otherwise, it creates confusion. It's not right also to use different words, and that is what it means. Now, definition requirements, if there are there, which is subsection 3, which is talking about that if particular offense does not have a specific name, then the charge must include sufficient details about the definition of the offense to inform the person accused of the nature of the charge. It might happen that those things are not defined. Then in one word, you cannot define. You have to ensure that in the charge, it is properly described because there is no definition available. So a proper uh, sufficient detail has to be added. And this is very critical to ensure that the accused has adequate notice concerning what acts or omissions has constitute the particular allegation. Because we know this is a fundamental right of the person that they should be aware of what exactly they are being alleged of so that they can bring the appropriate defense against that. Now, subsection 5 says that the legal conditions of the statement. So basically, by making the charge, it is implicitly stating that the all legal conditions are required to continue the offense have been met. So if it is said so and so section, so and so ingredients have been has happened, then what exactly it means is that implicitly, please understand, this kind of offense is already committed and all the ingredients which are required to complete the condition is met. So this is something which underscores the prosecution has fulfilled necessary legal criteria before bringing the charge. So they have all the necessary evidence, stories, etc. Subsection 6 talks about the charge should be in the language of the court, which is the drafted in the language of the court and ensuring clarity and comprehension for all the parties. It should not be very concise. It has to be detailed up to reasonable detail. It cannot be Ramayana or Mahabharata or a Quran. So including the accused. So everybody will understand that. And that is why the courts are into regional jurisdiction. And whatever the language of the court adopted in that region has to be done so that the person who is in that area should be able to understand it without any difficulty. Then subsection 7 talks about the previous conviction and their effect if has to be brought into the conviction and the punishment now. So if the accused has a prior conviction, that could lead to enhanced penalties. For example, somebody was previously charged with 15 different offenses. For example, this famous rape case in the Pune, the person has got about 19 previous convictions or cases running against him, where he was somebody who has committed robberies, he has committed theft, and multiple other such crimes he had already committed. So, if that particular accused has a prior conviction, and that could lead to the enhanced penalties for a new offense. For a new offense, then it shows the what is very important for the court is what is the conduct of the person, what is the character of the person, because that is something which is deciding the impact of the punishment. Say, for example, for the same theft of a packet of bread, two people could be punished differently. And that is also a very famous case in Pune. So, where one person who was very hungry and he was in Pune only, he was an ex-IT personnel, he lost his job and then he had nothing to eat. So, that person's character and the conduct is shown by his past. So, that will something which will not only enhance, that will also help to enhance the safety that he is not punished accordingly because he was not a criminal, earlier it's a situational thing just to specify his hunger, he has done that. While the same place, the other person who is a shoplifter and who has been doing it, just out of uh, being somebody who wants to do that, and he has got some previous history about that, then that has an impact on the in the charge. So the specifies, this is basically, which is something specifies that the previous conviction, the fact, what was it, the date when it happened, and place, so that we'll know that what is the area under which the person has normally operate. Is it a very wider perspective the person has operated? What a date, how long, how many years, month or weeks before or days before he has again done that? And what was the fact around that? Is it something which could be considered to incriminate that person's behavior as being a person of that conduct and character? So these things are essential to understand the context and potential increased severity of the forthcoming sentencing. Now, this is something which will use to potentially increase the person's sentencing. That is why this is used, and this will also give an indication that this person will also probably continue to commit such crimes again, or some new kind of crimes again. Say, for example, a person has a linearly been doing theft, and suddenly he has done some digital crime. Then basically this person has now enhanced this area. He has moved from a physical theft to a digital theft also. So, which is a far more dangerous thing. The person has evolved in the area of crime into the new kind of crime. So, this person has actually put his all efforts and intentions to ensure that he is the one somebody who will do further more higher order of crime. So, that is something which will be noted, and that will be having impact. But that person who has a history of 5 different thefts, he does a pickpocketing, is a smaller offense, then it is still considerable that he will be aligned and press the charges against him and the conviction for the theft, because he has almost done the same thing. So he is a thief. So that is the impact which is which it will have. So the courts may amend the charge to include this information before the sentencing phase if it was initially omitted. So it was, and if such statement has been omitted, the court may add it at any time before sentence is passed. So because to charge a person, it has to show that you have done this and you are somebody who is capable of doing that. So let's see the illustrations now. Illustration A says A is charged with the murder of B. So A is charged with the murder of B. He is alleged to murder B. So this is equivalent to a statement that A's act fell within the definition of murder given in section 100 and 101 of the Bharatiya Nyaya Samhita, which was earlier 300, 302, 1, 2, etc. So this is something which is the definition of the murder given in 101 and 102, 100 and 101, that it did not fall within any of the general exception of the said Sanhita, and that it did not fall within any of the 5 exceptions to the section 101 thereof, or that if it did fall within the exception 1 or other of the 3 provisions to the exception applied to it. So this is something which is very much clarified in illustration 1. What it says, that when charging A with a murder, the illustration basically what is putting the effect here is, the clarification here is that the charge implied when he is charged with a murder of B, the moment the word is used as charged with murder of B, it automatically implies everything, whatever is what could be under the cover in terms of the laws and the sections. So it automatically will mean that the all definition and exceptions in the law regarding the murder will apply automatically on in the relevant sections, meaning A has an action which is fit within the legal parameter necessary for a murder charge. If we come back and say a murder, attempt to murder, then that way, and so forth. Subsection illustration B says A is charged under subsection 2 of section 118 of the Bharatiya Nyaya Samhita with voluntary causing grievous hurt to B by means of an instrument for shooting. This is equivalent to a statement that case was not provided or by subsection 2 of section 122 of the said Samhita, and that the general exceptions did not apply to it. So if somebody is charged under, you are charged under subsection 2 of section 118 of BNS with voluntary causing grievous hurt means he is only charged for that, and he is not charged with anything else, which means it has to be very specific in the charge. Either you put in the English language or you put the sections. The English language will have everything encompassed, encapsulated into it. What does the definition of that means in that particular sections of the particular law? That is why the same word has to be used. If somebody change the word to a charge with instead of murder of be saying act of causing death to be, then it will be difficult to ascertain as per the parallel definition defined in the sections in the particular law of IPC or BNS, that what does it mean exactly. So it has to be containing the exact definition word so that it means the same and it can be related with the sections automatically. It's like a automatic reference which will happen to those sections. Or if A is charged under subsection 2 of 118 of BNS, then it means definitely means it does not something uh, which is under a specific section, and that the detail which is has been given of a grievous hurt must be addressed without any relevant exceptions and applying according to the established legal definition. Now we are very specific here, subsection 2 of 118. So we only mean that. Now illustration C. A is accused of murder, cheating, theft, extortion, or criminal intimidation or using of false property mark. So this charge may state that A committed murder or cheating or theft or extortion or criminal intimidation, or that he used a false property mark without reference to the definitions of those crimes obtained in the BNS. But the section under which the offense is punishable must in each instance be referred to in the charge. So what does it mean is this particular illustration, what we are seeing is that the charge can identify multiple offenses without needing to prove definitions each time, simplifying the charge while still referencing applicable legal actions because the keywords are referring there. So it is a multiple charge option of section illustration A, where we only talked about murder. We are talking about cheating, theft, extortion here. So even if you put murder, cheating, theft, extortion, automatically it will refer to those sections of the law. Illustration D says A is charged under section 219 of BNS, which intentionally obstructing a sale of with intentionally obstructing a sale of property offered for sale by lawful authority of a public servant, and the charge should be in those words. So basically, what does it mean? That it is very clear the straightforward term regarding A's obstruction of lawful authority. So this is something A is act of obstructing the lawful authority of a government servant, and this illustrate clearly exemplifies that how the charge would be or should be clearly communicate the alleged wrongful act. So this is something which is very clearly saying it is something related to in scope of 219. So whenever it is named and in that particular definition of that particular law, it automatically refers to the relevant sections. And if it is very specific of section or subsection, it means only that and nothing else. So basically, it is what the section is doing is bring in clarity, consistency with regard to the law under which the punishment is sought or an offense is committed, and streamlines the judicial process because then universally the same language is being spoken everywhere, and it is something which is also given a right to fair trial to the accused because then he has been specifically very clearly cut out into those areas of offenses for which he is being charged under the charge through the very specific definitions or the specific sections and the subsections. So that is the beauty of this particular section, which one should understand. These are very sometimes very less understood sections when it is utilized or tried to understood. So sometimes people don't understand the value of these charges. This is something which is putting the base ground for those charges for the accused, and it automatically refers to the particular definitions. Let's move to the next section, 235, which is Particulars as to time, place, and person. So this section says that the charge shall contain such particulars as to the time and place of the alleged offense. Because until and unless you don't have a time orientation or a geographical orientation, how would you refer to that particular crime? And that is something which might also have a very important aspect of the crime as well, or the offense as well. For example, place is of a very important essence. For example, if you talk about somebody has picked up and somebody has thrown somebody out, and if this has happened at a public place, or this has happened inside the private property of that person where he has thrown the person out who has interfered by you to use of his property and trespassed, and the time is also very, very important then when this has happened. So that might also have multiple implications in that sake. So the charge shall contain that the particular as to the time and place of the alleged offense and the person, if any, against whom, or the thing, if any, in respect of which it was committed. So against what it was committed. So was it committed against a person or a thing, or a property, animal, person, whatever it is. So it was committed are a reasonably sufficient to give the accused notice of the matter with which he is charged. So this has dual value. One is it will give a very clear understanding to the accused also, without any confusion that for which offense this thing is being talked about, this charge is talking about. And the judiciary also benefits out of it, that the justice system will also have a very clear recording of what had happened. And it brings, the more you make it very specific and clean, the more the chances of putting less of the vexatious claims, so fake claims, etc. Subsection 2 says when the accused is charged with a criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum, or as the case may be, describe the movable property in respect to which the offense is alleged to have been committed. So one element is when you're talking about money, then the sum has to be also brought in. It makes completely sense to specify the sufficiently what is the sum which is in question and which particular property we are talking about, and the dates between which the offense is alleged to be committed. Because a financial transaction or a misappropriation or a dishonest um, um, uh, misappropriation of the property, breach of trust has happened in which duration, because that is something which is very, very important. Where did you had a right to manipulate that property, or did you had a right to was it possible for you to do a criminal breach of trust at that point of time? So all those things is also helping the accused also. So offense, so that has to be also added in without specifying particular item or exact date, and the charge so framed shall be deemed to be a charge of one offense within the meaning of section 242, provided that the time included between the first and the last such date shall not exceed 1 year. So basically what it says is the subsection, this particular section basically, which is, if you see the overall, it is outlining the requirement for including specifics around the charge, which is the date, time, place, sum, etc., etc. So it has to be very much specific and quantified in the value wherever it is required. And basically it is in ensuring that the sufficient details are added into the to inform the accused about the allegation, and facilitating a fair trial also, maintaining the integrity of the judicial process by exactly putting what exactly is the relief sought after. So requirement of the particular is given in subsection 1, where it talks about the time, place, person or thing involved, who is involved, who was the person who was got impacted, etc., etc. So the victim, etc., is something which has to be brought in, and these particular are very important to for the reasons I just mentioned. Subsection 2 is talking about the specification for criminal breach of trust or dishonest misappropriation of money, etc. What it says is, so the situation where the accused is charged with a criminal breach of trust, then this refers to the case where an individual misuses trust regarding the property or fund. And dishonest misappropriation means involve unlawfully taking possession of money or movable property with the intent to deceive a person. So it is sufficient in these cases to bring in the gross sum, which is involved in the So subject of this kind of misappropriation or breach of trust, and indicate the dates over which the offense alleged has happened, provided it is framed without the any need for exact date or specific item. It's a lump sum is also okay, just to give an idea. So indicate the dates over which. So indicative is also fine. Now the charges are constructed will be treated as a singular offense under the stipulation of section 242 of the Bharatiya Nyaya Sanhita, and the time limitation is also attached with this, which is the specific time between the first and the last date mentioned cannot exceed 1 year. So ensuring that the charge remains within reasonable time limits or temporal limits, as we say. So there is a time limit which is given to ensure, for all the reasons what we studied yesterday also about the limitations. So it is a clarity which has to be given to the accused and to the court, and the clear complaint filed by the person who is impacted. It is a very the flexibility has been given in terms of that the a broader timeline etc has to be given, where not an overly detailed requirement of the minute second calendar is required. Roughly an idea is fine, and it encourages a prompt legal action by putting a limitation of 1 year of such particular uh, for offense which has happened. So the specified time has to be first and the last date cannot be exceeding 1 year. So this is about section 235. Let's move to section 236. When manner of committing offense must be stated. Now we have been talking about the charge, the structure of the charge, the basic sanity of the charge, the details of the charge, and then manner of committing offense must be stated. So we talked about the quantification of the charge. What is the impact happen in terms of the number, etc. And what exactly is the detail about the time and the place, etc. But how it was committed. So when the nature of the case is such that the particular mentioned in 234 to 235, etc., do not give the accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the manner in which the alleged offense was committed and will be sufficient for that particular purpose. So basically, it outlines the condition under which the manner of committing the offense must be included. What are the conditions and how it has to be done? So it says when the detail provided in 234 to 235 failed to give a clear indication, sufficient notice to the regarding the matter they are charged with, the charge must include specifics about the manner in which it was alleged offense was committed. So this ensures that the accused has clear information regarding the nature of the alleged act and their opportunity to prepare a defense. So every time this is something which is given as a opportunity to defend also. So illustrations are given to further understand it. For example, A is accused of the theft of a certain article at a certain time and place. The charge need not set out the manner in which the theft was affected, because it is very clear that the A is accused of stealing an article at a specific time and location, and the charge does not need to be basically describe how the theft occurred. Theft is theft. And as the particular provided are sufficient for the accused to understand the allegation, the person will understand it was mine, you have picked up in so and so place and so time, it is theft. So there, what else is required to explain that? Now, illustration B says A is accused of cheating B. Now, this is something which has an element of psychology and the mind, where you really cannot exactly tell what is cheating. Cheating could be of any nature, any kind, right? It could be done in multiple ways. It could be done by becoming a fake Baba. It could be become by a fake seller. It could be done by any other means. So A is accused of cheating B at a given time and place. Time and place is fine, but then how the cheating has happened, it is very, very important for the accused also to understand and defend, the court also to understand. So the charge must set out the manner in which A has cheated B. So how it was executed, why it amounts to cheating. So it must describe, because the specifics on the how A operated against B, and how the this particular thing was committed, that will help to actually prove or later point of time, and to explain the accused at that point of time the understanding of the nature of the accusation what is against him. So then that is something which needs the set out the manner in which A has cheated B. Now illustration C. A is accused of giving false evidence at a given time and place. So again, A is accused of giving a false evidence at a given time and place. So he is given a false evidence. The charge must set out the portion of the evidence given by A which is alleged to be false. Because now if you come back and say A has given a evidence which is fake for time and place, it is not sufficiently explaining the situation. Then in the whole of the evidence what he has given, what is the part which was something which is alleged to be false. So that is something which is very, very important to provide the clarity and it is very vital for both the accused and the court. Illustration D says that A is accused of obstructing B, a public servant, in the discharge of his public function at a given time and place. Now, the charge must set out the manner in which A obstructed B in the discharge of his function. Did he went ahead and created a ruckus? Did he went ahead and hold B by his hands or through his people? Or did he erected a wall or something in front of him? What was the exactly way in the manner how he obstructed, because the time and the place is not only something which will be able to give the clear picture. So it has to be followed the rule. What rule has to be followed in the illustration is you should be able to close your eyes and visualize what exactly and how it has happened. If that is not sufficient, if I close my eye and I say A has done a theft of so and so article from B, I don't need to explain anything beyond that. But the moment I talk about A has cheated B, I say A and B sitting there, and the allegation is A has cheated B, then how? That question will come. So that is why it is very, very important. So illustration D is talking about obstruction. So then the charge has to clearly should bring in the detail about how the obstruction has happened. And it is very crucial to understand the context of the alleged offenses and see how serious it was also. Because if somebody is obstructed by raising their hand or their spreading their arms and not letting a public servant going is a different thing than if somebody is putting a gun in front of the person or a knife in front of the person and stopping, or with a iron rod in his hand. So this also gives the depth and the intensity of the problem. Now let's move to point E, illustration E. A is accused of the murder of B at a given time and place. The charge need not set anything beyond that A murdered B. So it does not mean he was murdered with a iron rod, he was murdered with a knife, whatever it is. A has murdered B at a given time and place. The charge need not state the manner in which the murder was done. Illustration F talks about so the basic element of the offense are eminent from the charge only. F is A is accused of disobeying a director of the law with intent to save B from punishment. So he has disobeyed the directions of the law with intent to save B. Now the charge must set out the disobedience charged and the law infringed. So basically what is the understanding? So it brings us a very clear clarity, this section. It brings in the balance, detail and the whatever are the brevity around this, and it gives a judicial discretion also, where the court may also come back and ask about such things, and then the charge is framed. So this is 236 and then 237. 237 says words in charge taken in sense of law under which offense is punishable. So in every charge, the words used in describing an offense shall be deemed to have been used in the sense attached to them respectively by the law under which such offense is punishable. This is almost same to the very first section what you have studied. So this is the section which clarifies how the terminology which is used in charge is interpreted in relation to the applicable law governing the offense. So which what is very, very important in the justice system is the right or the appropriate interpretation. So whatever the legislature makes the law, whatever words are defined, the courts are there to interpret it, and to interpret it properly going ahead also. This is how it has to be. So basically what it says is that the legal interpretation of the term has to be respected. So any word which is used in the charge to describe an offense shall be interpreted in accordance with the meanings assigned to them by the relevant law under which the offense is punishable. So this is an operational section which is applying now what we have studied in the first section, and that is what it is saying, that you have to use it. In the very first section it says in the appropriately the definition what is given, you have to use it as per to describe if there are no words given, etc., to give a reference to those sections which are connected to that particular defined word in that section. So that is why then it says when you have done that, then any word which is used to charge in an offense should be then interpreted according to the meaning assigned to them by that particular relevant law. So this is an operational section which says now you operate it the way it is configured under the laws. So this means that the legal definition interpretation found in the statutes are the authoritative meaning, and it has to be followed. And it is ensuring that there is no ambiguity which has to be taken out how the terms are understood, because the instructions in the previous sections are already given around that it should not be used that way. So once it is done that, then there should not be an ambiguous meaning which should be coming out of and should not be used that way. So the charge should reflect the exact legal language and definition, and it should be interpreted also the very same way. And if the term like theft is used, it will be interpreted according to legal definition in the law. If the murder is used, it is murder. If it's a rape, it's a rape. It's a gang rape, it's a gang rape, etc., etc. So there is no understanding which has to be pushed apart from that. So very first thing is the ingredient is we have to configure it accordingly where we are using it properly. And then once it is configured properly, the charges, it cannot have a second meaning out of it. So there is a prohibition of taking any other colloquial or other kind of understanding out of these particular charges once it is framed according to. So it is again helping to bring in the clarity and consistency from when you have drafted the charge from the point when you have interpreting it also. So at the stage of when you are interpreting a charge, we have to believe and understand it was configured that way and no other second meaning comes out of it. A murder is murder, it cannot be considered theft or rape. So it is something which is instructions to even forget to try about any misinterpretation and believe it as it is in front of the eyes and read it and interpret it as it has to be done under that particular law and section. So this reinforces the legal standard. So while it reinforced before this section about how to put those things, once those things are put in the document, then you have to reinforce that the legal standards are maintained when you read it back again and interpret that also. So that is section 237. So 238 then naturally talks about the effects of error. What is the effect of error? So no error in stating either of the offense or the particulars required to be stated in the charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material unless the accused was in fact misled by such errors or omission and it has occasioned a failure of justice. So basically it addresses how the error or omission in the charge do not automatically invalidate the proceedings. If that happens, they will only be considered significant if they mislead the accused and result in a miscarriage of justice. So until and unless this doesn't happen, it is not automatically invalidated. So let's take some deeper understanding of this, that basically it is acknowledgement of the law that mistakes in stating the offenses or the required particulars are not inherently This is not by default detrimental to the case. Error or omission will not be treated as material unless they misled the accused in a manner that has compromised their ability to defend themselves and result in a failure of justice, which is very rare because even the charge, when it has happened and you have made some mistake in putting something there, but the whole trial during that duration cannot be completely misled by that. So this principle supports that the notion that the justice should be determined based on the substantive issue and the not mere a small procedural misstep can cause a detrimental effect. Let's take some illustrations. So A is charged under section 180 of the BNS with having been in possession of counterfeit coin, having known at the time when he became possessed thereof that such coins were counterfeit. So he knew this is counterfeit because to make consider a crime, the person has to commit a crime. If somebody is not knowing and not aware of that, not having that mental ability and picking up a counterfeit coin and moving in the market, a 5-year child, has he be, can that person be alleged to have committed crime? No. So this person under 180 has somebody who is in possession of counterfeit coin, having known at the time when he became possessed thereof that such coin was counterfeit. Now the word fraudulently being omitted in the charge, which is part of the section. So with fraudulently, this person has done it, which is omitted in the charge. So somebody has missed. Unless it appears that A was in fact misled by the omission, the error shall not be regarded as material error. So this is something, not something very important. So having been in possession of counterfeit coin, having known as the time when he became possessed thereof that such coin was counterfeit and fraudulent being just being missed, uh, unless it is not apparent that he is in fact misled by this omission, the error shall not be regarded as material. That is what this part says. So he would not be misled. This is a very word which will not make much difference into understanding that what the kind of offense he has done and for which the whole trial is happening and tomorrow for what he will be convicted also. Let's take illustration B. A is charged with cheating B, and the manner in which he cheated B is not set out in the charge or is set out incorrectly. So maybe it was not put at all, and if it was put at all, it was incomplete or incorrect in some sentence formation. So A defends himself, calls the witness, and gives his own account of the transaction. So he says, no, no, not exactly this way, this way. The court may infer from this that the omission to set out the manner of the cheating is not material. Because end of the day, even if the manner is here and there, a bit here and there, what is more important is the cheating definitely has happened. So it is not something material. He cannot just come back and say, as like we do in some of the trials where if the material which is based on which some complaint is made, if that is something which is faulty, then the case might be completely uprooted also. But in this case, what is important is cheating. What was the purpose of giving the manner? To give a far more detailed understanding to the court and the person that this is how you have done and this is the allegation. But if it is here and there something missed or little bit faulty, it will not be considered material because end of the day, the cheating is something which is important, and in spite of that, if the cheating is happening, it is immaterial. So this is something about illustration B. Now, see, A is charged with cheating B, and the manner in which he cheated B is not set out in the charge, missing. So there were many transactions between A and B, and A has no means of knowing to which of them the charge is referred and offered no defense. The court may infer from such fact that the omission to set the out the manner of the cheating was in the case of material error. Now, what is this scenario? To better understand, for example, A and B are two businessmen who are into the business of A is supplying material to B and handing over checks to him where B is delivering his articles. Now, there are in a year, say 100 transactions which happen between both the parties. And at one instance, he has not paid or he has given some check which was by mistake, which was of a bank account which was closed earlier or whatever it is. But whatever the cheating allegation had come, if A is charged with B without giving exactly that which transaction they are talking about out of the hundreds of transactions, it is a material error. Then how would the accused will also know how to defend, which is the primary objective of giving the details, and how would the court will also operate, and which part has to be examined. This is similar to the previous section where we talk about if somebody gives a false evidence, that part of the evidence has to be brought forward. Very same way, if there are multiple transactions happen, it has to be definitely makes sense to bring in that particular transaction to ensure the person has uh, uh, means to know which part of the transaction they're talking about, and then he can defend himself, he or she. Subsection illustration D says A is charged with murder of Khuda Baksh on the 21st January 2023. So he has been charged with the murder of Khuda Baksh on 21st January 2023. In fact, the murdered person's name was Haider Baksh, and the date of the murder was 20th January 2023. A was never charged with any murder but one, and had heard the inquiry before the magistrate, which referred exclusively to the case of Haider Baksh. The court may infer from these facts that A was not misled and that the error in the charge was immaterial. Because again, as per the what we are seeing in illustration B, what A is being charged is murder of somebody X. So if some small here and there something has happened, typing error or whatever it is, or wrong dictation at that point of time, whatever has happened, or some date issue here and there, but what exactly A is charged as an individual is of a murder of an individual. That is something which is still happening. So the whole of the trial is not invalidated just because of this. Because A indeed has murdered A or B. A has murdered indeed B or C. So it does not matter. He is actually has done something which has killed somebody. Now, illustration E says, so A was never charged with any murder but one, and had heard the inquiry that way. So that is why the court will infer that A was not misled and the error in the charge was immaterial. So this is very, very important. So this is exactly same the situation in B. Now E. A was charged with murdering Haider Baksh on 20th January 2023, and Khuda Baksh, who tries to arrest him from that murder on 21st 2023. When charged for the murder of Haider Baksh, he was tried for murder of Khuda Baksh. So a witness present in this defense were witness in the case of Haider Baksh. The court may infer from this that A was misled and that the error was material. So in this case, the man is charged with murdering B on so and so date of 2023 January. And Khuda Baksh, who tries to arrest him for that murder on 21st January 2023. So when charged to the murder of Haider Baksh, he was tried for the murder of Khuda Baksh. Now this is completely different because the witness which is present in the defense were witness in the cases of Haider Baksh. So he kills Haider Baksh, he kills Khuda Baksh, then he is tried for actually for Khuda Baksh while he is being charged for murder of Haider Baksh, and then the witness is of the other murder. So this is a complete jumbled situation. In this case, this is definitely a very big mistake, and this is something which is considered in this case. So this is why this section is there. This section is there in place of fairness in the proceeding. The fairness in the proceeding has to happen, and it should not just be hampered by some small errors. So it gives a protection also to the hearings and the just delivery of the justice system. And again, it's a something which is helping to the right of the defense to the person also, because he has to be charged for exactly what kind of offense the person has done. In this case, in the last example, if you come back and say he was anyways charged for murder, but then both the murders are different. The trial cannot have happened that way, in which the other murder will happen and the scenarios, facts, and the witnesses cannot be interchanged because they are two different subjects of matter. So in this case, it is although talking about the murder of these two people, but then each has to be tried singularly, which is you see in some point of time in today's lecture only. So at the moment, just keep it in mind. We'll come back to that. So Section 238 talks about the effects of error, which might uproot a particular matter and causing this kind of mistake or omission will cause a failure of justice, or it is immaterial and not impacting, and it's something which is not material in the case of considering it has occasioned in a failure of justice. Now, Section 239, court may alter charge. So what does it says? This is talking about the authority of the court to alter a charge. So subsection 1 says, any court may alter or add to any charge at any time before judgment is pronounced. So alter is making changes and add is adding some new things. Subsection 2 says every such alteration or addition shall be read and explained to the accused, because it always follows the same steps in BNSS or CRPC, the very same way every step is operated. So if it was supposed to be explained and read at the time of the first charge, it will continue whenever there is an alteration or addition which is happening. Now, subsection 3 says if the alteration or addition to the charge is such that proceeding immediately with the trial is not likely, in the option of the court, to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may, in its discretion, after such alteration addition has been made, proceed with the trial as if the alter added charges have been the original charge. So the very first subsection talks about basically that the court has authority to alter add. That is what it says. And before the judgment is pronounced. So at any point of time. Subsection 2 says that the communication of charges which has to be explained whenever such alteration or additions are made, to ensure that the accused is fully aware and he continues to defend his cause, so that he is adequately putting his defense in line with the additional or altered charges. He has to change his stance of defense. He might to bring in additional defense, etc., etc. Now, proceeding with the trial after alteration, which is subsection 3, it says that the court concludes that the alteration or addition will not prejudice the accused or the prosecutor, and it may continue with the trial as if it is something which is the original charge. And this is the mechanism, basically, which is something which is helping the streamlining the trial process, minimizing unnecessary delay while ensuring the justice fairly. So if the alteration addition to the charge is such that proceeding immediately with the trial is not likely, in the opinion of the court, to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may, in its discretion of alter such alteration or addition has been made, and proceed as if it is the original charge. Subsection 4 says if the alteration or addition is such that proceeding immediately with the trial is likely. So previous one was not likely. This one is likely, in the opinion of the court. So to prejudice the accused or the prosecutor as aforesaid. The court may either direct a new trial or adjourn the trial for such period as may be necessary. So if this particular alteration or addition which is happening, that proceeding immediately with the trial is likely, in the opinion of the court, to prejudice the accused or the prosecutor aforesaid, the court may either direct a new trial or adjourn the current one. So if the court determines that the changes could unfairly impact either of the parties, so if it will prejudice the accused or the prosecutor. In this one, it is causing the uh, prejudice to both the people, and casting there is a doubt on the fairness of the trial, then it may choose to direct a new trial or adjourn the correct trial for a period necessary to ensure fairness. And this is something which provision reflects the importance of equitable legal proceeding to both the parties, and allowing the space to proper procedural adjustment to ensure that the procedures are not coming in the way of actual delivery of the justice system. Subsection 5 says, if the offense stated in the altered or added charge is one for the prosecution of which previous sanction is necessary, the case shall not be proceed with until such sanction is obtained unless sanction has been already obtained for a prosecution on the same fact as those on which the altered or added changes is founded. So what does it says? It says basically that if the new or amended charge involves an offense that has required prior sanction for the prosecution. If there is a sanction required to uh, do something, uh, some sanction is required to charge somebody for that particular sanction for the prosecution, then the case cannot proceed until such sanction is obtained. So, if you're charging for something additionally or altering to get into that bracket of the charge, then it has to be first taking the permission, the sanction has to first taken, unless it has already been secured for a prosecution based on the some facts. So, this basically ensures that the necessary legal procedures are followed before proceeding with potentially serious charges. Because if there is a option, there is a situation of sanction which is given, then definitely there is some kind of bar of straight away putting allegations, and there might be chances that these things might seriously impact somebody. So in that case, the court may alter changes, or in these cases of alter and added changes, the court has to actually follow the necessary legal procedure to accept those kind of, and before the proceeding could start. So they have to, until this is not, sanction is not provided, they have to wait until that point of time. So if we quickly review this 5 section, first one is a ground rule which says court may alter add charges before any point of time. So it gives a option, you can do it before judgment. Number 2 says whenever you do it, you have to explain to accused. 3 and 4 are two opposite situations where the this alteration addition will not cause prejudice to anybody, and 4 will cause prejudice to anybody. So in fairness and equitable right, if if it is not causing prejudice to any of the parties, proceed as if it was part of the original charge. If it is causing prejudice to either or both of the parties, then you have to stop. And either you have to try a new trial or adjourn until that is something which is sorted out. And number 5 is talking about when it needs a sanction of a very, very serious charges, we need sanction, then court has to wait. And until that point of time, once the sanction is not received, you cannot proceed. And then if it is sanctioned also in point 5, then it will again take a route of subsection 3 or 4, depending upon if it is causing a prejudice or not. So again, the from number subsection 5, the reason of subsection 3 and 4 might arise as the case may be. Now, section 40, recall of witness when charge is altered. So when you alter a charge, the situation of recall of a witness has come up. So whenever a charge is altered or added by the court, as the procedure in 239, after the commencement of the trial, the prosecutor and the accused shall be allowed, number 1, to recall or resummon and examine with the reference to such alteration or addition any witness who may have been examined, unless the court, for reasons to be recorded in writing, consider that the prosecutor or the accused, as the case may be, desired to recall or re-examine such witness for the purpose of vexation or delay or for defeating the end of the justice. Now, there is a judicial control. I'll come back to it. Then subclause B says also to call any further witness who the court may think be material. Now, what is the situation? Then you have altered or added some kind of new charges and you want to recall the witness. Recall is call again. So, the subclause A and the B says that to recall or resummon and examine with reference to this particular alteration or addition, because there might be some new kind of examining facts might be brought into the notice of the court through this particular recalling those witnesses, etc. For the new alteration or addition, although the witness has been already examined, but for reason which is recorded in writing, So this is something which is, if it is considered that the either of the parties desire to recall, they can go ahead and do it, as the case may be desired to recall, reexamine such witness for the purpose of vexation or delay for defeating the end of the justice. So recall, examine who may be examined unless the court for reasons to be read. So this is a discretion of the court. So every time what it says is under 240A is, you as a party is allowed to re-examine, recall the particular witness, but then it is a discretion of the court. Then how the discretion of the court is entertained, then you have to make an application. So that party has to make an application that for so and so reason, for so and so addition or alteration of the charges, we want to call against so and so witness, and why? Because the reason is so and so. And then it's a discretion of the court where the judge will then, or the magistrate will make a decision that, okay, fine, you can call him, or if the court believes that this is just for the purpose of fooling around or delaying the matter, the reason given in the application is not appropriate, the court has all reasons to deny that particular permission. And they're also allowed to call any further witness also, which the whom the court may think to be material. So again, if you have added something new and if you have altered something new, they might, either of the parties can come back and say, we want to bring in some more witnesses, which will again suffice to the cause and the reason of the altered and the added charges. It is also the discretion of the court that the court is allowing it or not. If the court feels it is material by the application with a reason given to the court may allow. Otherwise, the court may decline to agree on this. So basically, there is a right given to recall to the witness or calling a further witness to both the parties, but it is completely upon the discretion and satisfaction of the court. So this is given a tool, but it has to be used appropriately and correctly, and that is something which is ensured by the judicial oversight, which is given by the particular court. And adaptation to such changes, etc., is ensuring a fairness of the material. (241) Separate charges for distinct offences. This is what I mentioned earlier when I talked about the separate charges and distinct offences. So the section says, is it part of our syllabus? First of all, no, it is not. So we have to go into 247. I think this is part of the other chapter. I'll come back to this when the chapter comes. 247 is part of this chapter. So 247 says, withdrawal of remaining charges on conviction on one of several charges. So when a charge containing more heads than one is framed against the same person, so the charge is containing more heads than one is framed against the same person, and when a conviction has been had on one or more of them, the complainant or the officer conducting the prosecution may, with the consent of the court, withdraw the remaining charge or charges, or the court of its own accord may stay the inquiry into a trial of such charges or charges, and such withdrawal shall have the effect of an acquittal on such charge or charges unless the conviction be set aside, in which case the said court, subject to the order of the court setting aside the conviction, may proceed with the inquiry into or trial of the charge or charges so withdrawn. So what does it says is basically a legal framework is given for handling the situation where multiple charges are there brought against an individual and a conviction occurs only on one or more of those charges. What happens to the remaining? Because there is a strict accountability which is inherited the moment a charge is instituted and the charge is framed, and that has to be definitely brought to an end. So it is a section which is talking about handling the multiple charges. So when a single charge which is encompassing multiple allegation or heads, and the court reaches a conviction on one or more of those allegations, either of the procedure or the following of the procedure have to be followed. The very first one is withdrawal of the remaining charges. So the complainant or the prosecuting officer may choose to withdraw the remaining charges. So then that they can do, provided they receive consent from the court to do so. So if they want to do that, they have to give a reason. And if court is aligned, they are allowed to do so. Now, this allows for a streamlined process, avoiding unnecessary trial and to charges maybe which are redundant probably after the conviction has been secured on the related allegations. So then that is taken to a closure. Alternatively, the court itself may decide to stay the inquiry or trial on those remaining charges. And this means that the court can pause proceedings on those charges independently of the parties involved. So the court can also take its suo motu cognizance in that direction. Now, what is the effect of withdrawal? So the withdrawal of the remaining charges is treated as an acquittal regarding those courts. And this means that the accused is not found guilty of those charges. Acquittal means not found guilty of the charges that have been withdrawn, which is a formal legal determination that they are not liable for those specific allegations. Why it is considered acquittal? Why it is not considered completely withdrawn or discharged in that case? Why? The reason is then it is again giving a safety to the accused also, that for the same thing he has been acquitted by this court, which were the charges framed against him and which were the remaining balance. And in that case, an acquittal gives a protection to the accused that, yes, these charges were against him, but he was found not guilty. So being called found not guilty and just forgetting about makes a lot of difference. It's a legal protection given to the accused that I'm sorted in that direction. And this is decided by the court that I'm not guilty in those points. Now, implication if the conviction is set aside. So if the earlier conviction or any charge is later set aside by the higher court, the court that has initially withdrawn the remaining charges or stayed their inquiry may then proceed with the inquiry or trial on those charges. So if the conviction itself is set aside on any charge, so if the earlier conviction of any charge is later set aside, then they have to proceed with the inquiry trial on those charges, because then it is again a situation where still the conviction has to happen, and it provides a mechanism for reopening the cases that has been paused or withdrawn, and contingent upon the outcome of the appeal or the review, it happens. So basically, it's a streamlined legal process on the withdrawal of the charges on which the convictions has not happened. It brings a fairness and transparency to the accused also, and it gives a judicial discretion to decide through the higher court also, in case if they want to set aside the conviction, and then the court which on which order, on whose order this particular it was set aside, then that will proceed to the inquiry into trial or charges so withdrawn. Okay, so now we move to chapter 4, which is general principle to be tried separately for every charge and its exceptions, section 241 and 246. So we have one example we're talking about when the multiple heads are there, then how this is handled. So let's go to chapter section 241. Now we come to section 241. This is a section from 241 246. This is general principle to be tried separately for every charge and its exceptions. Chapter 4. So this set of sections which are coming from chapter 18 of BNSS, which is commencement of proceedings before magistrate, part V, which is joinder of charges. So separate charges for distinct offenses. So for every distinct offense, we have seen the example in the previous chapter also. Person is charged with theft, murder, robbery, rape. So for every distinct offense for which the person is accused, there shall be a separate charge, and every such charge shall be tried separately. So provided that where the accused person by an application in writing so desires and the magistrate is of opinion that such person is not likely to be prejudiced thereby, the magistrate may try together all or any number of the charges framed against such person. Subsection 2 says nothing in subsection 1 shall affect the operation of the provision of 242, 243, 244, and 246, we will see now. So illustration is A is accused of a theft on one occasion and of causing grievous hurt on another occasion. A must be separately charged and separately tried for theft and causing grievous hurt. So basically, this is section 241. The subsection 1 talks about that basically this is the ground rule that the every distinct offense for which a person is accused must be formulated as a separate charge. This principle will ensure that basically that each offense is adequately addressed also in legal proceeding and allowing for meticulous examination of the fact and evidence related to each charge. Why? So that the person who is a victim, of course, gets a justice, but then accused is also getting the justice because it is always a justice which is the system is run to ensure that the person who is alleged to be an offender until and unless is not found guilty is also having the equitable right to fight and get justice under fair trial. Now, subsection 1 also talks about that each charge shall be tried separately, which is fostering a clear understanding for the accused and the court also that the nature of the allegation and the evidence which are pertaining might be separate also for both of them. So then there is an exception for the joint trial which is given, where the provision has completely giving an exception where the accused has the option. So this is an option given to the accused that multiple charges to be tried together through a written application to the magistrate, and the magistrate must then, under his discretion, must determine that the accused is likely to be prejudiced by such a consolidation or not. So this is the always the benefit of the accused is also seen. And if the magistrate finds it appropriate and believes that joining the charges will not disadvantage to the accused, it should not be disadvantaging the accused. So they may proceed to try the charges together. And this flexibility will assist in streamlining the court, of course, the consolidation will help. But then it is on instance of the accused, as the provision says, but then also on even now, when the instance of accused is happening, it has to be ensured that the accused is not prejudiced, he is not disadvantaged. And on that consideration, the magistrate can take that option. Subsection 2 talks about that the section is very clearly saying the subsequent provisions which are outlined further, which we'll see now, will uh, nothing in this section will affect the operation of these sections. So this is something which is giving a very clear fairness to the accused, and this is something which is bringing clarity on the running of the trial and right to the proper defense to the person up to the level where even if he or she, the accused, is making a mistake of requesting for a joinder, in that case also, the magistrate has to take a decision to ensure that it is still fair for him to defend himself and not bring him to some kind of disadvantage. Section 242 says that the offense of same kind within year may be charged together. So then it talks about instruction about same kind of offenses of what duration in the whole history of the offenses the accused has done could be clubbed. So subsection 1 says when a person is accused of more offenses than one of the same kind committed within the space of 12 months from the first to the last of such offense. So of course you will count from the last offense backwards, whether in respect of the same person or not. So he has done theft in A's bungalow or B's bungalow or C's bungalow. So in respect of the same person, or he has done the theft in A's bungalow 3 times. he may be charged with and tried at one trial for any number of them exceeding 5, not exceeding 5. Subsection 2 says offenses are of the same kind when they are now, when they say in the first subsection offenses of the same kind, then how do you define? They are punishable with the same amount of punishment under the same section of Bharatiya Nyaya Samhita or any special or local law. So this is the test condition to identify they are punishable by the same amount of punishment and same section of BNS. So provided that for the purpose of this section, an offence punishable under subsection 2 of section 303 of Bharatiya Nyaya Samhita shall be deemed to be an offence of the same kind as an offence punishable under section 305 of the said Samhita, and that an offence punishable under any section of the said Samhita or any special or local law shall be deemed to be an offence of the same kind as an attempt to commit such offence when such attempt is an offence. So this section basically talks about the legal framework that allows a multiple offense of the same kind committed within a specific time frame to be charged and tried together for that particular accused, whether it is done against the same person or not. So this is something which is given. Now, the subsection 1 says that when an individual is accused of multiple offenses of the same kind committed within 12 months from that date, the first offense committed to the date of the last offense may be charged together in a single trial, and the number of offenses that can be together is capped at 5. So you can cap maximum 5 offenses in one single charge. So this is something which help to avoid the fragmentation of the trial process for related offenses and promoting efficiency and coherent in legal process. It is actually going to help because if there are five particular offenses which are committed within 1 year against one person or multiple persons, it is something which will reinforce the belief of the court also, and to even if out of five, 4 cases are very strong or 3 cases are very strong where strong witnesses are there, it will automatically help the cause of the other 2 cases also, because then within the same matter, the person's character and the conduct is proved. Subsection 2 talks about that the offenses are considered to be of same kind if they are punishable under the same section of the Bharatiya Nyaya Samhita or any relevant special or local law, and they carry the same potential penalty. What is the potential penalty? Which is the same amount of punishment is given, and this is the classification which establishes a clarity which offense can be grouped for trial purpose. So those offenses could be grouped. So for example, proviso talks about that the section includes a provision which is talking about this section is that an offense punishable under section 2, subsection 2 of section 303. 303 is what? 303 is theft or BNS. So if somebody is punishable under subsection 2 of section of theft, then what is the subsection 2 saying? So subsection 2 of 303 says whoever commits theft shall be punished with imprisonment of either description of a term which may extend to 3 years, or with fine, or with both, and in case of second or subsequent conviction of any person under this section, he shall be punished with rigorous imprisonment for a term which shall not be less than 1 year, but which may extend it to 5 years, and with fine. So is deemed to be of the same kind of an offense punishable under section 305. What does 305 say? Whenever commits theft in any building, tent, vessel, etc., on means of transport, etc., of any article of good and idle, or any property of government of local authority, shall be punished with the imprisonment of either description of term which may be extended to 7 years and shall be of liable of fine. So theft in a dwelling house or mean the transportation or place of the worship, etc. Basically, both are theft. And 306, if we see, these are not matching. So then we come to section 306. Now see the difference. So 306, now what it says? It says, Whoever is being a clerk or servant or being employed in the capacity of a clerk or servant commits theft in respect of property in the possession of his master or employer shall be punished with imprisonment of either description of term which may extend to 7 years and shall also be liable to fine. So punishment and fine both are there. So theft by clerk or servant on property or in possession of particular matter. So any this means that there are specific offenses that can be combined despite potentially differing legal descriptions are completely different. It's talked about one is talking about theft inside the property, while other is talking about which is theft by the particular master's property. So any offense which is punishable under a given section or special or local law is regarded as the same kind as an attempt to commit that offense as long as the attempt is recognized as an offense which is theft. In this case, flexibly allow for a broad application of the section and encourages a more comprehensive approach to prosecution. Now, 305 and 303 and 305, when you read the definition, it does not matches, but basically it's the same kind of punishment and it is basically same kind of offense, which is theft. As we have seen in the previous chapter, by theft we can always categorize things which are done in the in the uh, commitment of any such kind of action which is considered end of the day a theft. So this is all subsections which are part of the same particular chapter theft, and this is all committing to basically theft only. First 303 is talking about theft only, while 306 talks about theft by clerk, but it is theft again. So these could be clubbed together in spite of having several things, because this is showing the character and conduct of the person. What clubbing it to showing that he can do theft in any of the conditions. So where theft is common. So that is the common grouping ground that this person is committing theft in all the situations. So he is basically a thief that has to be proved. And he is thief in all the different aspects which are described in the Sangita for different flavors of theft. So he is expert in more areas. He's a very good thief. So efficiency in legal proceeding is enhanced because then the person's character as a thief is proved in this section, and it is a protection against the multiple prosecution also, because then everything is clubbed. You can then make one punishment of the theft, whichever is the largest one in those one which are clubbed, and you can close the particular commencement of the trial. So then how the trial for more than one offense will happen in this case, which is section 243. So if in one series of acts so connected together, previous one, 303, 305, 6, as to form the same transaction, more offenses than one are committed by the same person, he may be charged with and tried at one trial for every such offense. So then in this is a little different when an individual commits a multiple offense in a series of connected act and forming a same transaction. So in one transaction could be done in multiple steps, and they may be charged and tried together for each offense. But this provision ensure that the related offenses are resolved into a coherent manner during a single trial, which can save time and resources. So multiple things he has done, but end of the day he has done one crime, and that is one which can be uh, clubbed together. Subsection 2 says when a person charged with one or more offenses of a criminal breach of trust or dishonest misappropriation of property as provided in subsection 2 of section 235 or in subsection 1 of 242 is accused of committing for the purpose of facilitating or concealing the commission of that offense or those offenses, one or more offenses of falsification account, he may be charged with and tried at one trial for every such offense. So this is the special case where we talk about the criminal breach of trust and falsification of account, financial crimes. So if a person is charged with an offense related to criminal breach of trust or dishonest misappropriation of property, and they are also accused of falsification of account, which is also there, aimed at facilitating or concealing those offenses, the law permits all related together to be tried together. So this allows for a comprehensive examination of the actions and motives involved. So this is if somebody is doing a criminal breach of trust and dishonest misappropriation property, and that person is also charged of falsification account, which is nothing but an action which is part of the same active result which will finally cause the criminal breach of trust or dishonest misappropriation. So all of them has to be then clubbed into he may be charged with and all has to be tried as one trial for every such offense. So tried at one trial for every such offense, because end of the day, all of them are committed for the same one purpose to achieve. He might have also gone and he might have taken out some ledger and he has seen something which he was not supposed to see. The data privacy also he has violated. But everything has to be tried under one umbrella, because this is all committing to one offense. Subsection 3 says, then if the act allegedly constitute an offense falling within two or more separate definitions of any law in force for the time being by which offenses are defined or punished, then the person accused of them may be charged with and tried at one trial for each of such offenses. So this is a multiple definition when it is coming. So it is all in the 303 to 305. It was a similar definition of that. Now it is a multiple definitions. If the alleged uh, act which has happened, it is constituting an offense that fell under more than one distinct legal definitions, the accused can be charged with and tried for each of those offenses. And this is further supporting the principle. What principle? Of addressing all relevant offenses arising from the same conduct in a cohesive trial. Subsection 4 says, if several acts of which one or more than one would by itself or themselves constitute an offense, constitute when combined a different offense, the person accused of them may be charged with and tried at one trial for the offense constituted by such act when combined, and for any offense constituted by any one or more of such act. What it says is combination of the acts. So previous one was multiple definitions aggregated. This is combination of the acts, which is if several acts are happening, and these several acts, some of which would independently qualify as an offense. So he has committed ABCD multiple acts, and in these acts, some of them are independent, qualify as an offense, combined to form a different offense. So the accused may be charged with both the combined offense and the individual act. And this provision enhance the flexibility of the legal proceeding by recognizing the interrelated nature of the certain criminal actions. For example, somebody has gone for a theft and then somebody has murdered also somewhere there. So it is a separate. Theft is one head and murder is one head, so which are independently qualifying as an offense. He might have done more offenses in between. Say he's jumped the wall, he has broken a lock, and so many things he has done. But then these are two separate, distinct qualifying as an offenses. So he should be then must be charged with both the combined offense and the individual act. So he has also committed a murder, and he can also be tried with a murder during the theft, intensifying the act punishment for the theft. So what the other act is doing is intensifying. We have seen that the intensification can happen for a punishment depending upon the other facts which are added and the other crimes which has same person has committed. Then subsection 5 says nothing contained in this section shall affect section 9 of the Bharatiya Nyaya Samhita. So the section notes that the stipulation do not affect the operation of the section 9 of the Bharatiya Nyaya Samhita, which may contain relevant provision to help to the or exceptions regarding the trial of the particular offense. So section 9 of the will not be impacted, whatever is part of the section 9, which is the limit of punishment of offenses made up of several offenses, and that is what is defined in section 9 of the BNS. So what it does overall, this section is giving an efficiency in the judicial proceeding, where what has to be clubbed, what not has to be clubbed is something which could be defined, and a single combined trial will help and make it more efficient. So let's see some of the illustrations under section 243. So illustration to subsection 1 and 3 are given here, and 4 also. So 1 is given. 1 is what? If one series and act so connected together as to form the same transaction, more of offenses than one are committed by the same person, he may be charged with and tried for one trial for every such offense. So illustrations given for 1 is a rescues B a person in lawful custody, and in so doing causes grievous hurt to C, a constable in whose custody B was. So A may be charged with and convicted of offences under subsection 2 of section 121 and that of section 263 of BNS, because he has committed, during the commitment of this offence, he has committed multiple things. He has rescued B from a lawful custody, and he has also uh, brought a grievous injury to a constable who was in custody of that person. So he could be tried under section 121, which is voluntarily causing hurt or grievous hurt to deter public servant from his duty, which is 121, or 263 of the BNS, which is resistance or obstruction to lawful apprehension of another person. So that is what is coming in this illustration. A commits house breaking by day with intent to commit rape and commits in the house so entered rape with B's wife. A may be separately charged with and convicted of offences under 64 and offences under section 331 of the Bharatiya Nyaya Samhita, which is the punishment for house trespass or house breaking, while the other one is for the rape. So he may be separately charged with and convicted of offences under both of them. Illustration C says A has in his possession several seals, knowing them to be the counterfeit and intending to use them for purpose of committing several forgeries punishable under section 337, which is forgery of record of court or a public register, etc., and may be separately charged with and convicted of the possession of each seal under section 341, which is making or possessing such seals. So either of them or both of them. D says with intent to cause injury to B, A institutes a criminal proceeding against him. So to cause injury to B, A institutes a criminal proceeding against him, knowing that there is no such just or lawful ground for such proceeding, and also falsely accuses B of having committed an offense, knowing that there is no just or lawful ground for such charges. A may be separately charged with and convicted of two offences under section 248, which is the detailed dishonestly making false claim in the false charges of offences made with intent to injure. So A has with intent to cause B falsely accused him of the committal of an offence, knowing there is no just or lawful ground for it, but he has done that. On the trial, A gives false evidence against B. So he is made one mistake and he is repeating the mistake again by again making a second offense of the same type, where he has given a false evidence again in the court, which is also again a wrong thing. So then he has committed the mistakes of section 248, which is false charge of offense make him to intend to injure that person. So that is something which he has committed twice. The clause E says A with intent to cause injury to be falsely accused of having committed an offense, knowing that there is no just or lawful ground such as on trial he gives a false evidence. So then he will be tried for a false evidence also. F says A with 6 others. So 6 more people are doing that. Commits the offense of rioting. They are doing a riot and grievous hurt and assaulting a public servant, endeavoring in the discharge of his duty as such to suppress the riot. So A may be separately charged with conviction of offences under 117, 191, 195, depending upon uh, uh, the definitions of these particular sections. 117 is voluntarily causing grievous hurt. 191 is rioting itself, and 195 is assaulting or obstructing public servant when suppressing riot, etc. So he will be maybe separately charged with and convicted of offences under all of these. A threatens BCD at the same time with injury to their persons with intent to cause alarm to them. So he threatens BCD at the same time. A may be separately charged with and convicted of each of the three offences under subsection 2 and 3 of section 351 of the Bharatiya Nyaya Sanhita. So he has threatened B, C, and D at the same time with injury to their persons so that they to cause alarm to them. So he is trying to inculcate fear in them. And he has done it simultaneously with all the three people. And he could be convicted of each of the three offences under subsection 2 and 3 of the section 351, which is criminal intimidation. So he can be punished against these three times offences. So what does it says is, in this illustrations we see A is something who is grievous hurt he is giving to a constable while actually committing a crime of rescuing. He will be convicted of both the offences. He is doing a housebreaking while he is doing a rape also. So in that case, housebreaking and rape both. C and D, which C is where is a several seal he is brought in. So he could be punished for uh, keeping those such things and committing the crime also by using them. D and E, where the person causes injury to B. In the first instance, he is committing the instituting a false case against him and then also accuses him to commit the same thing in the court. So twice the same section. Or E, in which case he has falsely accused him of a commencement of an offense and again given a false evidence also. So punishment for evidence also, false evidence also. In this, the person has with six other commits an offense of so many types, and he could be punished with all of them by hurt, rioting, and preventing somebody from suppressing a riot. And in this case, he has done multiple times the same offense with the same three people. Three times it will be applicable. Now, illustration to subsection 3 is given further. So subsection 3 talks about if the acts alleged constitute an offense falling within two or more separate definitions of any law in force for the time being, by which offenses are defined or punished, the person accused may be charged with and tried at one trial for each of such offense. So illustration is A wrongfully strikes B with a cane. A may be separately charged and convicted of offenses under subsection 2 of section 115 and section 131 of the Bharatiya Nyaya Sanhita, where 131 is punishment for assault or criminal force otherwise then on grave provocation. So without a grave provocation, if some kind of assault or criminal force is done, 131 is something which is applicable, and then 115 is voluntary causing harm to somebody, hurt to somebody. So A will be charged with and convicted for offences under these sections. Now, illustration I says several stolen sacks of corn are made over to A and B who knew they are stolen property for the purpose of concealing them. A and thereupon voluntarily are assisting each other to conceal the sacks at the bottom of the grain pit. A and B may be separately charged with and convicted of offences under subsection 2 and 5 of section 317 of Bharatiya Nyaya Sanhita. So they can be charged and convicted of offences under these two sub sections of section 317, which is stolen property related. J says A exposes her child with the knowledge that she is thereby likely to cause its death. It is going to she is going to cause its death. The child dies in the consequence of such exposure. A may be separately charged and convicted of offences under section 93 and 105. 105 is punishment for culpable homicide not amounting to murder, and where 93 is exposure and abandonment of a child under 12 years of age by parents or person having care of it. So in this case, she has committed both of them and may be separately charged and convicted of offense under both the sections. A dishonestly uses a false document as a genuine evidence in order to convict B, a public servant, of an offense under section 201 of the BNS. A may be separately charged with the offense of 223 and 340. So either of them, the person may be charged. Now, illustration to subsection 4 is given is if several act of which one or more itself is a constitute an offense constituted when combined as a different offense. So both the could be done. The person of them may be charged with and tried with one trial for offense constituted by such act when combined, and for offense constituted by any one of more of such acts which is independently a crime. So A commits a robbery on B and in doing so voluntarily cause hurt to him. So A may be separately charged with and convicted of offences under subsection 2 of section 115 and subsection 2 and 4 of the section 304. So 115 is voluntarily causing hurt and 309 is causing robbery. So he could be punished under either separately charged and convicted of offences and under these two acts, these two sections of the act. So this is trial for more than one offense. I would say that you go ahead and read it once again because it's a bit confusing, differentiating between all of them. I will certainly come back with it tomorrow once again, once we are starting the session. I'll once again revise and give you an opportunity to read it first, so that it's very well and easily settled in your mind. So at the moment, we'll move to the next section, which is section 244. Where it is doubtful and what offences have been committed. So, if a single act or same act, series of acts is of such a nature that it is doubtful which of the several offences the fact which can be proved with which will constitute the accused may be charged with having committed all or any of such offences, and any number of such charges may be tried at once, or he may be charged in the alternative with having committed someone of the said offence. So basically, it is charging multiple offences, which is part of the subsection 1 of 244. So when it is very uncertain that which specific offence which is arising from the set of action and the accused may be charged with. So what exactly which action? And with all the relevant offences that could be applicable. So this allows basically the court to consider that full range of potential charges based on the circumstances according. So the court can consider the full range of those charges, potential charges. And the section permits any number of these charges to be tried simultaneously, promoting the judicial efficiency. So it can be either of any of them, any range of it. So alternatively, the accused may be charged in the charge in the alternative also. So that is the prosecution might present different charges as possibilities without requiring a definitive conclusion on which offense was actually committed at the onset of the trial. So A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. He may be charged with theft, receiving stolen property, criminal breach of trust and cheating, or he may be charged with having committed theft or receiving stolen property or criminal breach of trust or cheating, and so on and so forth. So basically, A is accused of actions that could be classified as theft, receiving stolen property, criminal breach of trust, or cheating, etc. But in this case, A may be charged with any combination of those offenses. So any permutation combination of these offenses he could be charged with, and allowing the legal process to determine most appropriate charge based on the evidence presented. So any combination could be picked up, and depending upon the legal process, evaluation can happen later to determine based on the evidence presented actually what has happened, which one is the most appropriate one. Subsection 2 says, if in such a case the accused is charged with one offense and it appears in evidence that he committed different offense for which he might have been charged under the provision of subsection 1, he may be convicted of the offense which is shown to have committed, although he was not charged with it. So that conviction for the uncharged offense also can happen. So if the accused is charged with one offense, but evidence emerge indicating that it is of different kind of offense the person has committed and it was charged differently, then still conviction can happen on the offense where it was not explicitly mentioned in the original charge. So this provision enhances the ability of the justice system to ensure accountability, allowing for a conviction based on actual behavior regardless of the initial charge. So by this point of time, we stop for a moment and try to understand the relationship between the charge and the actual conviction which happens. Please understand, charges has to be very clear. Charges has to be very detailed, has to be with the means. Charges could be with a liberty given under section 244, could be framed with the option of various permutation and combination. But what actually is determining and not disturbing is if the charges have slipped upon some offenses or missed to frame it correctly, etc., etc. The what is primary of value to the court is the evidences and the proof of those particular situations of the offenses which the person has actually committed, and it does not relies upon the charge itself. It is finally the outcome because of the witness which is of the prime importance to the court in convicting somebody. It is not that if you are not charged and later it is surfacing out, the person would be left, because then becomes a situation which is helpless situation for the judiciary. Then a person who has actually surfaced out and by some reason the charges could not have been framed or missed at some point of time, the criminal will escape in front of the eyes in a very helpless situation. That is why the conviction is based on the actual behavior of that person, and regardless of the initial charge and actual behavior of the crime what he has committed, actual nature. So illustration B says in the case mentioned, A is only charged with a theft. It appears that the committed the offense of criminal breach of trust or that of receiving stolen property. He may be convicted of criminal breach of trust or of receiving stolen good, as the case may be, though he was not charged with such offense. So A was charged with theft only, while A is accused of act which may amount to either of them. So it appears later that he committed the offense of a criminal breach of trust or that of a receiving stolen good, while he was only charged with theft, while there was a possibility at the start to charge him for each of them, and he was only charged for one of them because there is a liberty to do that. So he may be convicted of criminal breach of trust or receiving stolen goods, as the case may be. Now he was not charged with such an offense, he was charged with theft only. The illustration C says A states on oath before the magistrate that he saw B hit C with a club. Now, before the sessions court, A states on oath that B never hit C. So, in when he was first time in the magistrate's court, he said that he saw B has hit C with a club, a rod. And when the magistrate appreciated that this particular case has to be committed to the session court, the court has gone to the session court, either it was committed or probably for an appeal, etc. The session court A states on oath, the same person A says that B never hit C, and that is what his statement on oath. A may be charged in the alternative when convicted of intentionally giving false evidence, although it cannot be proved which of these contradictory statements were false. Just because by his behavior, regardless of the any charge against him, it was not a charge against him. But then he has completely 360-degree opposite, 180-degree opposite. He has given a complete different statement about the position of B with respect to C's injuries, and that is what something which is which will cause a such kind of conviction to him also. So it is court's ability to address dishonestly regardless of the original context of the testimony. So in this case, this is a very different example than compared to A and B, where at least we are talking about the charges being there, not there, properly framed, missed, etc. for the person who's accused. In this case, A is not an accused. Accused is who? B. But in spite of that, the person could be convicted in spite of there is no charge against that person. Section 245, when offense proved included in offense charged. So when the offense which is proved, which is included in the offense charged. So when a person is charged with an offense consisting of several particulars, a combination of some only of which constitutes a complete minor offense, and such combination is proved, but the remaining particulars are not proved, he may be convicted of the minor offenses, though he was not charged with it. So what is this section says in subclause 1 is it talks about the conviction for minor offenses. So when a person is charged with a complex offense which has induced several particulars, if a combination of some of these particularly constitute a complete minor offenses. So there are complete minor offenses are also part of the combination which is for which he is charged with. So he has charged with a complex offense that includes several particulars, multiple steps have been done. and multiple details are available, and a combination of some of these particulars constitute a complete minor offenses. The accused may be convicted of that minor offense if that combination is proven, even if the other particulars of the original charge are not established. So this is which is acknowledging that the complexities of the criminal behavior can allow the courts to deliver justice accurately based on the proven facts. So whatever is proved, it is punished on. That doesn't matter what combination, minor or major. Then second sex subsection says when a person is charged with an offense and fact are proved which reduce it to a minor offense, he may be convicted of the minor offense although he is not charged with it. So those were minor offenses which were never charged. You were never charged on it. So reduction to the minor offenses, which is subsection 2, it says if an individual is charged with a specific offense and evidence is presented that reduce the charge to a lesser minor offense, the individual may be convicted of the minor offense irrespective of the court's flexible whether it was included in the original charge or not. Normally, minor charges would not be there. This gives prosecution and the court flexibility to ensure that the appropriate penalties reflect into the actual circumstances of the case. They have to ensure that. Subsection 3 says when a person is charged with an offense, he may be convicted of an attempt to commit such offense, although the attempt is not separately charged. So, conviction of an attempt, what it means. So, basically, an individual which is charged with an offense, he may also be convicted for attempting only to commit that offense. So, only for attempt. Even if the attempt was not separately charged, attempts are not charged separately, or maybe not charged in this case. The provision allows for the accountability when the accused conduct meets the criteria for an attempt also, and thereby recognizing the full scope of their actions and their responsibility. So, attempt also is something on which the person could be convicted in this scenario. And subsection 4 says nothing in this section shall be deemed to authorize a conviction of any minor offense where the conditions requisite for the initiation of proceedings in request of the minor offense have not been satisfied. So if there is something which is there is no conviction for a minor offense can occur unless the necessary conditions for initiating proceedings regarding that minor offense have been satisfied. So we've read the necessary conditions for proceedings for such things yesterday. So if those conditions are not fulfilled, it cannot be the person cannot be convicted for them. So this requirement safeguards that the right of the accused is also taken care, where all of these, the witness, etc., are all provided before those things are going against him. So illustration number A is given that A is charged under subsection 3 of 316 of the BNS with original breach of trust in respect of property entrusted to him as a carrier. So he was taking some property, maybe a car he's delivering to some other location. It appears that he did commit criminal breach of trust under subsection 2 of section 316 of the Sanhita in respect of property, but that it was not entrusted to him as a carrier. He may be convicted to criminal breach of trust under subsection 2 of the section 316. So this is the, if we read the plain wording of section 316 2, you will understand it better. Let me read it for you. So section 316 2 says, whoever commits criminal breach of trust shall be punished with imprisonment of either description for a term which may extend to 5 years of fine or with both. So what does it says is, A is charged under subsection 3 of 316 of Bharatiya Nyaya Sanhita, which is reading as 3 is, subsection 3 reads as, whoever being entrusted with property as a carrier. So this is something specific to a carrier operating, while 3162 is specific to the person. So A is charged under 3163 of the BNS, which is a criminal breach of trust regarding property entrusted to him as a carrier. And if it is proven that he committed criminal breach of trust under 316, but the property was not entrusted to him as a carrier, he may be convicted for a criminal breach of trust under the mentioned subsection 2. So depending upon what exactly is being proved, and that particular, when offense is proved, included in the offense charged. So it is a minor offense but then this is what is proved, so this will be taken in. Uh, Illustration B says A is charged under subsection 2 of section 117 of the BNS with causing grievous hurt. He proves that he acted or grave and sudden provocation. He may be convicted under 122 of the Sanhita. So he was charged under a major more serious offense under 117 of doing a grievous hurt. But then the minor offense is proved where under sudden provocation he has done. So that brings the accountability to a lesser extent. So as this minor thing, which was not even he was charged with, but then something this could be considered for the conviction for this person. So this makes a flexible legal proceeding to in interest of the accused also. Although the justice is given exactly as it was supposed to be given, but this brings a help to the accused also, because then if it is proved end of the day that the person has committed a lesser crime, in spite of that minor offense which is not charged, he will be punished for only that charge, not for something the higher order which is being alleged against him. So last section for this chapter is section 246. Let's get into section 246, where what persons may be charged jointly. So we have talked about the joining the allegations against a person, the offenses against a person. Now we're talking about what persons may be charged jointly. So the following persons may be charged and tried together, and namely, persons accused of the same offense committed in the course of the same transaction. So two robbers are committing same offense committed in the course of same transaction. Persons accused of an offense and persons accused of abetment or attempt to commit such offenses. So the planning of that particular bank robbery and the people who have gone ahead and done the bank robbery, etc., etc. Persons accused of more than one offense of the same kind within the meaning of section 242 committed by them jointly within the period of 12 months. So when the people who are um, who have of more than one offense of the same kind they have done under section 242, which is false personation for purpose of act or proceeding in suit of prosecution. So they have made a fake CBI team. So the persons accused of more than one offense of the same kind within the meaning of section 242 committed by them jointly within the period of 12 months. So all of them, they could be charged together. And persons accused of different offenses committed in the course of the same transaction. So to do a bank robbery, they have done a theft of a car in between. They have broken some lock. They have tried to steal some weapons, etc., etc. So everything is in course of same transaction they have done. Number E, the persons accused of an offense which includes theft, extortion, cheating, or criminal misappropriation, and persons accused of receiving or retaining and assisting in the disposal of such property, possession of which is alleged to have transferred by such offense committed by the first named persons or of the abetment of an attempt committed. So they are both are set of people could be tried together. And number F says persons accused of offenses under section 25 of 2 and 5 of section 317 of BNS and or either of those sections in respect to stolen property and possession of which has been transferred by an offense. So, which is the dishonest misappropriation of property possessed by a deceased person at the time of his death. So, in this case, uh, whoever has done, or 317 says the stolen property, transfer of stolen property. So person who are accused of offenses under 2, 3, sorry, is the stolen property handling, the BNS or either of those section is respect to such people who will do jointly this could be tried together. And number G is says persons accused of any offense under chapter 10 of Bharatiya Nyaya Sanhita relating to the counterfeit coin, currencies, stamp, etc., etc., and persons accused of any offenses under the said chapter relating to the same coin or abetment or attempting to commit any such offense, and the provisions contained in the former part of the chapter shall all may be applied to such charges, because this is all what we're talking about, the gangs. We are talking about the gangs here, all of that. So provided that where a number of persons are charged with separate offences and such persons do not fall within any of the categories specified in this section, the magistrate or the court of session may, if such person be an application writing so desire, and if he is insatisfied that such person would not be prejudicially affected thereby and is expedient so do try all such persons together. So what is the category for joining the joint charges for this such kind of gangs is person accused of the same offense. The individuals accused of an offense which are along with those accused of the appointment or attempt to commit, they have all done it together. Or the persons who are done more than one offense of the same kind of together within 12 months of time, which is of impersonation, etc. Several individuals who have caused different offenses part of the same transaction, then also they can be tried together. Individual charged with offenses like theft, extortion, cheating can be tried with those who are receiving those person money, etc. Persons accused of offenses under section 317, either of the section 2 and 5 related to stolen property, they are also all could be tried together, and those of you accused who are doing this crime of counterfeiting coins, etc. But then there is a provision given at the end, which is provision for separate offenses is also given, which there is a group of individuals charged with the separate offenses not specified within the proceeding categories. So is which is something not part of these categories, and this group of individuals charged with the separate offenses, which is not part of these which are listed here, the magistrate of court of session may, upon a written application, if the application is given by them from the accused individuals, decide to try all of them together in spite of that also. If that is not part of this category also, they want to be tried together, it can be done. And this provision required the court to ensure that no party will be prejudiced by such a consolidation of trial, no party is both side, and balancing the efficiency with the fairness. So this is a judicial efficiency which is inculcated by keeping the gangs who are committing the crime together to be tried together and give a fair representation also in case if it has to be done, and effective use of resources and support for the justice which happens through this section. So this is basically a section which is talking about people who have committed together mostly, which could be considered and said as a gang.